Good afternoon, everybody. Welcome to our panel discussion on LGBTQ rights. It's nice to have everyone assembled here, and we're going to record this, so if people couldn't attend, at least hopefully the information will be available to others across campus. I want to thank the School of Politics, Security, and International Affairs and Director Gunesh Teskor for sponsoring this, as well as the Pride Faculty and Staff Association for their sponsorship and participation. We have three presentations, 4 people speaking today. What we thought we'd do is provide an overview of some of the cutting issues that our panelists have thought are important in LGBTQ rights. Beginning of a conversation, we want to open it up to a dialogue after the presentations. And the panel also thought it was important to not only look at national issues, but to look at state and even local issues. I mean, there's a lot going on right here on campus in the state of Florida and across the country. We could even bring in international concerns if the discussion goes that way. So just, in a few hours, there's a lot of material that can be covered. And so we're going to provide some overviews and then open it up for a conversation. I'd like to introduce our panelists. Now, maybe I'll just introduce them one at a time. Our first panelist is Patricia Farless. Patricia is Senior Lecturer in the Department of History, where she has taught courses in American history, women's history, and the U.S. legal system since 1994. The U.S. legal system since 1994. Her research interests include U.S. women's legal history, constitutional law, 19th century history, the Civil War, and Reconstruction. Patty earned a BA in History and Political Science and an MA in History, and is currently working on her PhD in History here at the University of Central Florida. Please welcome Patty Farless.
Thank you, everyone. And thank you so much, Marty. You made me sound actually, I don't know, cool. So thank you. I appreciate that. I wanted to also thank the LGBTQ faculty and staff for inviting me to present, because this is such an important issue. And so I'm setting my timer because I usually go overboard, so just bear with me. And I do apologize, I won't be able to stay for Q&A, but you're welcome. If anyone has further questions that you wanted to follow up, please feel free to go ahead and send me an email. I'm always happy to engage in conversations. So let me do this. I'm going to set the mood for our conversation that will be ongoing for the next couple of hours. And really what I'm doing is I'm looking at kind of the constitutional legal history in the very brief period, not going all the way back to the 19th century for the most part, but in just thinking about how have things changed dramatically since, the rapid change that happened in our recent times. So bear with me. I'm going to go ahead and set up my screen, and I'm not one of those who can chew bubble gum and walk at the same time. So just hang tight just a moment, and I will get this going on. And thinking about this, one of the things I like to do is I like to talk about 2 very critical amendments that are the crux of what has become rights for the LGBTQ plus community. And that is the 5th and the 14th Amendments. The 5th, of course, is guiding the actions and preventing what are seen as unconstitutional actions by the federal government on individual citizens. And then the 14th Amendment, which happens at the end of the Civil War in Reconstruction, really redesigns that relationship as well between states and citizens, and the role the federal government plays in helping to secure the rights of its citizens. And most specifically, what we're thinking about for these 2 amendments is we're thinking about things such as due process clause and equal protection of the laws. So that's, where we're at in terms of what I wanted to think about. So I want to talk about this being a very personal experience, not just a kind of a dry constitutional legal discussion. And in doing so, I'm going to sit myself in this conversation. And so one of the things that we have to think about in terms of changing rights is we're going to have to start talking about what were some of the things that happened in the federal government as well as at the state going on. But before we go further, let me set one more item up. And I want to set that item up of concepts of individual rights to privacy, especially in their relationships in the bedroom. Because while gay and lesbian people do not just reside in their bedrooms, those that are opposed to expansion of rights certainly believe that they do. So we have to factor that in. And one of the most important cases that came up is a 1965 case. And this was a case called Griswold v. Connecticut. And it was dealing with the right for married couples to have access or at least information about in terms of contraceptions, right? And if I could get that out, in terms of the law had been passed back in 1879. It was a law against essentially married couples being able to use any drug or any medical device or other instrument essentially for contraception. And it was back partly where you had these Comstock laws that were being passed at the state levels that were really trying to dictate morality across the United States. And in this case, this was a Connecticut law. So what happens is it gets challenged, and it gets challenged by the head of the Planned Parenthood, which was Estelle Griswold, also along with one of the chief gynecologists at Yale University, and his name was Buxton. And they end up getting arrested. They end up having and being ruled against. They see this as a way to challenge this law that prevents married couples from being able to have access to contraception. So the question that becomes in front of the court is, does the Constitution protect the right to marital privacy, right, against state restrictions? In other words, what people do in their bedrooms as married couples, and we're only talking about opposite sex couples, of course, does the state have a right to interfere with it? And on this, the Supreme Court, of course, actually rules that the state can't interfere in this. And the reason it does is it says, well, we think there's these zones of privacy, or you often hear them called penumbras, right? These penumbras of privacy. While there's not an explicit right to privacy in the Bill of Rights, all of the amendments taken together, and they put in there the first, the third, the fourth, and the ninth, they said kind of in the shadows of those amendments entails a right to privacy. And this is really important because the question is, well, what rights do we have as couples? And those of you that are looking at issues of abortion rights, this sets the stage for Roe v. Wade. And this is again in 1965. And that's for another conversation. I'm always happy to have that conversation. So for our purposes, though, in this conversation, so 1965, married couples have the right to do whatever they want in their bedroom, in terms of sex, in terms of contraceptions and what have you. But another case comes in front of us. And this case is 1986, Bowers versus Hardwood. And this case was dealing with a Georgia anti-sodomy law, dictated, created, I should say, against not just gay sexual intercourse, but really also affecting opposite sex. But in this case, this was essentially focused on a consensual homosexual sodomy incident. Michael Hardwood had been observed by Georgia police officers engaging in the act of consensual homosexual sodomy with another adult in his bedroom. How did they get in there? Yeah, exactly. So we have a Georgia statute that's criminalized this. And so the Supreme Court rules in 1965, yeah, you've got a right to privacy in your bedroom, not so fast for our 1986 Michael Hardwick, who is engaged in consensual sodomy in his bedroom with another adult. So it goes up to the Supreme Court, and the Supreme Court ultimately rules in a very narrow way. They said the question in front of us is, does the Constitution confer the fundamental right upon homosexuals to engage in consensual sodomy, for invalidating the laws of many states, which make such conduct illegal. So that's the question they're grappling with. Right to privacy, according to Griswold v. Connecticut, and by the way, Roe v. Wade. But the conclusion in this is no. The divided court found that there was no constitutional protection for acts of sodomy and that states could outlaw the practice. In fact, Justice Byron White argued that the court had acted to protect rights not easily identifiable in the Constitution only when those rights were implicit in the Constitution and the concept of ordered liberty, or when they were deeply rooted in the nation's history and tradition. That was the Griswold argument. The court determines that the right to commit sodomy did not meet either of those standards. In fact, White feared that guaranteeing a right to sodomy would be the product of judge-made constitutional law. We always hear that, right? And send the court down this road of illegitimacy. So why this is important is because ultimately this is going to be a case that will get challenged in the Lawrence case in 2003. We're not there yet. So what happens in the 1990s? All of a sudden, Bill Clinton, first Democrat in a long time since of course, since Jimmy Carter, but the Republicans had a strong hold on the presidency for decades, except for the blip with Jimmy Carter. So Bill Clinton gets elected, and he gets elected with a lot of LGBT support. And he had promised to get rid of to get rid of the laws that allow for their officers to ask soldiers if they would were in fact essentially gay. He promised to get rid of that, and instead we get what is called don't ask, don't tell. The officers can't ask as long as you don't tell us, you cannot be removed and dishonorably discharged, which created a wave of unhappiness and outrage among the gay community, only to be backed up by his signing of the Defense of Marriage Act in 1996. So that's a picture of me back in 1994. I was a lot thinner, a lot less gray, long hair. And here I'm thinking to myself, Bill Clinton and many of these Republicans, because remember he was Democrat, who were promoting this Defense of Marriage Act, were oftentimes themselves unfaithful in marriage, right? They were oftentimes themselves multiple divorces and remarries. And yet there's me, who was in a relationship at the time, faithful and what have you. And yet I would not be able to get married. So things start to change in 2003. Now, remember, we have George W. Bush elected in president in 2000. We've had 2 terms of Bill Clinton. And this case, the Lawrence v. Texas case, starts to change everything, right? So Bill Clinton had appointed several justices to the Supreme Court. And so the time becomes ripe. How are we going to test this, right? So in this Lawrence v. Texas case, 2003, the police responding to a reported weapons disturbance at a private residence. Sure, we'll go with that. Houston police entered John Lawrence's apartment and saw him and another adult man, Tyron Garner, engaging in private consensual sexual act. Lawrence and Garner were arrested and convicted of deviant sexual behavior in violation of the Texas statute that prohibited 2 persons of the same sex from engaging in certain intimate conduct. So we start to carve off and peel off what opposite sex couples can do versus what same-sex couples can do. And affirming, the State Court of Appeals held that the statute was not unconstitutional under the Due Process Clause of the 14th Amendment, because Bowers is the law of the land at this point. That was the last Supreme Court case. So the question eventually goes up to the Supreme Court. Does the criminal convictions of John Lawrence and Tyron Garner under the Texas homosexual conduct law, which criminalized sexual intimacy among same-sex couples, not identical behavior, but doesn't make it illegal by opposite sex couples for identical behavior, Does that violate the 14th Amendment, a guarantee of equal protections of the law? Do their criminal convictions for adult consensual sexual intimacy in the bedroom violate their vital interest in liberty and privacy protected by the due process clause? And the Supreme Court rules it is a violation of their rights. It is a violation. In a 6-3 opinion delivered by Justice Anthony Kennedy, the court held that the Texas statute making it a crime for two persons of the same sex to engage in certain intimate sexual conduct violates the due process clause of the 14th Amendment. The court reasoned that the case turned on whether Lawrence and Garner were free as adults to engage in the private conduct in the exercise of their liberty under the due process clause. 6-3 decision. I want us to think about that. I want us to remember that. Okay. One of the things we want to think about too, in response to that Lawrence case, you started seeing all these waves of states moving to pass laws that would ban same-sex marriage. Because even Scalia in this said, if you allow for this, you are going to open the door, right? So you see in 2000, 2004, 2006, 2008, because of the work being done on the ground, the 2004, in terms of the party platform for the Republican Party, this common sense law reaffirms the right of states not to recognize same-sex marriages, right? So that's happening in the 2000s and speeds up and accelerates as a result of that Lawrence case. But we also know that this was also because of what was happening at the ground level. Many organizations were working hard to push for same-sex marriage. What becomes that the moment where they try to say, okay, we're going to split the difference here, right, is Howard Dean, the governor of Vermont, signs into law civil unions, not marriage, civil unions, which there's not much of a difference. It has to do with church, but what have you. Okay. But the state of Massachusetts says, wait a minute. If you have same-sex couples only available and access to marriage by civil union, and opposite sex couples can get married with a whole new slate of laws and protections. That is creating a dual system of law for citizens that's dividing them. And in fact, the Massachusetts Constitution, according to this case, affirms the dignity and equality of all. It forbids the creation of second-class citizen, and civil unions would be second-class citizenship. And one part that we have to understand is this was something that was not embraced 100% by people that were same-sex in relationships, because the worry was if it was only allowed to have marriage, then we would get neither. And so this in itself was concerning. Certainly as a person, it felt better. But in the practicality of what would I have access to, two different things. In comes Edie Windsor. Edie Windsor, you know, if you haven't watched, I can't think of the name of it, the movie, the documentary of her and her wife, it is just beautiful and brilliant. And it doesn't surprise me that she's the one that pushed this case all the way up. So in 2013, we get what becomes known as United States versus Windsor. This is tackling DOMA. So not those laws that are being passed at the state level, but what Bill Clinton had signed into law, DOMA. So the Defense of Marriage Act, enacted in 1996, states that for the purposes of federal law, the words marriage and spouse refer to legal unions between one man and one woman. Since that time, some states started authorizing same-sex marriage. And so very simply, and of course, Canada that was also allowing for it. And in fact, one of the things that ends up happening is Edith Windsor, who had gotten, she was the sole executor and of the estate of her late spouse, the SPSIA, who died in 2009. They had been married in Canada, but their marriage was also recognized by the state of New York. When Thea Spire died, and I think she had MS, if I'm not mistaken, when she passed away, she left her estate to her spouse, Edith Windsor. But because of DOMA, because of the federal law existing at the time, she was imposed with a tax of $363,000. $363,000. Yet, had she been a man or had Thea been a man, and they had been in an opposite sex marriage, she would have paid zero. So quite a significant impact. So had their marriage been recognized, the estate would have been qualified for marital exemption and no taxes, zero would have been paid. And by the way, Disney, who was ahead of the ball on this, who had allowed for domestic partnerships for benefits, I was able to get access to them. And yet I would get a bill from the federal government saying our relationship is not recognized. And therefore, I was being taxed on those benefits. And so it becomes much more complicated than I just want to get married when our entire system is built based on this. And I got to hurry myself along, so I'm going to do just that. So what comes up in this case is, does the Defense of Marriage Act, which defines the term marriage under federal law as a legal union between same-sex couples, does that mean, does it violate the Fifth Amendment? Because remember, it's only the Fifth Amendment in this case, because this is the federal government. And the answer was yes. It is a violation of that. The Supreme Court, in a 5-4 decision, so I want us to think about that. Supreme Court held that the United States government, despite the executive branch's regarding of DOMA's unconstitutionality, retains a significant stake in the issue, and because very simply, Obama administration didn't support DOMA anymore, but Republicans had created a group to challenge and support DOMA. So very simply, they're saying, yeah, those Republican groups that had put this together, the United States government, because of taxation, because it has an interest, they have an interest and they can have standing. But here's what's interesting. Troubling on this is the court also held that states have the authority to define marital relationships, and that DOMA goes against legislative and historical precedent by undermining that authority. So it's throwing it back to the states. DOMA is unconstitutional. Why? Because it exists in the states. So if you were living in a state that did not allow for same-sex marriage, and in fact had explicit bans on same-sex marriage, like Florida did, you could be married in New York and not married in Florida. And while a opposite sex couple's marriage would be recognized from state to state to state, that was not the case for the same-sex couples. And in fact, one of the things we do is we get a couple of cases going up, and I just want to hurry up along, and I'm going to move it fast, called Brenner v. Scott and Grimsley v. Scott. And this becomes the case that essentially eliminates the ban on same-sex marriage in the state of Florida. And what happens in this, they issue an injunction banning the ban on same-sex marriage, but a stay was issued immediately on that, set to expire on January 6, 2015. So it expires, that stay on it. So at January 6, 2015, same-sex couples could go and marry. But we're still waiting for the Supreme Court to decide. So there's this window of time. The reason I call it uneven terrain, there's this window, this period of time where very simply people were getting married that were same-sex couples in Florida, and that may very simply come to an end. And I myself rushed out to get married. Because even though I was married in New York, I wanted to be married in Florida because I didn't think they could go back in, even if the Supreme Court ruled against same-sex marriage. But Obergefell is the case that we all think of, right? That hands down the decision by, and remember, this is again a 5-4 decision led by Anthony Kennedy. And the question is, does the 14th Amendment require a state license to marriage, does the 14th Amendment require a state to license a marriage between two people of the same sex? Does the 14th Amendment require a state to recognize the marriage between two people performed outside that state, right? conclusion, 5-4 decision handed down by Anthony Kennedy. The court held that the due process clause of the 14th Amendment guarantees the right to marry as one of the fundamental liberties it protects, and that analysis applies to same-sex marriage. So let me tell you real quickly, is this a done deal? 5-4 decisions. Swing vote right here, Anthony Kennedy. Anthony Kennedy is no longer on the Supreme Court. He was replaced, of course, by Kavanaugh. And remember, we have others that were appointed under the Trump administration. So is it a done deal? The answer is no. In fact, I'm going to be kind of a Debbie Downer for a moment. I can tell you with this existing Supreme Court, I would not be married. And I don't see the Supreme Court upholding that right going forward. I could be wrong. I hope I'm wrong. But this court is a much more conservative court. And one of the things that you want to think about is, well, what do I do? Nothing else can be done. Certainly, you can affect your laws at the state levels. You can affect your laws at the national level. If you don't think you have an interest in voter rights, if you don't think you have an interest in Black Lives Matters, if you don't think you have an interest in immigration, I assure you the other side does. They link them. And more importantly, something to think about is there is a need for activism that is unheard of in recent history. And yes, you can't do much about the Supreme Court right now, but you can ensure that future Supreme Courts will reflect changes. You can ensure that your state levels are reflecting those changes. But it will be a much more difficult battle than it was just a short 5 years ago. So I want to thank everyone for listening to me go on. I want to thank everyone for coming, and I do apologize for having to leave early, but I do, and I apologize, and thank you again. I greatly appreciate it.
Thank you, Patty, for that comprehensive overview of marriage equality. I know as a married gay man myself, that's important rights to me as well. And just being able to have the right to marry is groundbreaking for all people across the country. I know Patty has to leave. Can we take one or two questions for Patty if anybody has a question at this time? But please join me in thanking Patty again for those insights.
Thank you all so much. Be safe.
Our next speakers are Dr. Martha Brankel. Martha is professor here at UCF, where she teaches first-year writing and rhetorical theory. She writes poetry and fiction and has been published most recently in the Sea Letter, Clockhouse Review, Broken Ridge Review, Burning Word Literary Magazine, and Bryant Literary Review, among others. In 2000, she won the Central Florida United Arts Award for Poetry. Her first novel, Street Angel, in 2006, was nominated for a Lambda Award and a Triangle Award, and was a finalist for Fence Magazine's 2007 Best GLBT Novel Award. In 2019, Finishing Line Press published her poetry chapbook, Hard Letters and Folded Wings. Martha is a founding member of the Pride Faculty Staff Association, and she currently serves as treasurer for the GLBTQ+ Museum of Central Florida. Joining Dr. Brankel is Alexis Rodriguez. Alexis is a graduate student in the history program here at UCF and is vice president of the LGBTQ History Museum of Central Florida. His research interests focus on medieval queer subcultures within the Iberian and Maghreb region, theoretical discourses on sexualities, cross-dressing, and the role of memory within the development of modern-day LGBTQ movements and communities. Please welcome Martha and Alexis.
Okay, we have to use these mics so it will record to the presentation. So you have to put up with us a bit with that. It's not working. Is it working now? Okay. Okay. Can you make the first slide go? Alexis and I are going to kind of tag team. We work on the board of the LGBTQ History Museum of Central Florida. He's the vice president now, and I'm the treasurer. We tend to share these board roles. They just go around in a circle every year. But he's great to work with. I was so glad when he joined the board, and we have a good time together doing this. So do you want to start, or do you want me to start?
I can go. So in 1961, the Florida Johns Committee expanded its investigation to include homosexuals. So this is during the McCarthy era from 1950 to 1954. Florida began its witch hunts with the 1955 establishment of the Florida Legislative Investigation Committee, also known as Johns Committee, after its chairman, Charlie Eugene Johns. So by 1963, 39 professors and deans were fired. 71 public school teachers lost their teaching certificates, and scores of college students were interrogated, and many of them were expelled. In 1964, the Johns Committee published its report, Homosexuality and Citizenship in Florida, informally called the Purple Pamphlet. The report, which became infamous for its inclusion of images of homosexual acts, was a major factor in the demise of the Johns Committee on July 1st, 1965.
Yes, the McCarthy era wasn't enough for us in Florida. We decided we need to have our own little mini McCarthy era here. As Patty had talked about, in 2003, anti-sodomy laws struck down. We had also had one in Florida. And in November 5th, 1973, the US Supreme Court upheld the constitutionality of Florida's sodomy law. In Wainwright versus Stone, Florida statutory provision prescribing, and this is a quote, the abominable and detestable crime against nature, either with man or beast, we're very biblical in Florida, was not held to be unconstitutionally vague, as the court perceived no violation of the underlying principle that no man shall be held criminally responsible for conduct which he could not reasonably understand. The Floridians convicted of sodomy were assumed to understand the law's reach, even though it was written so vaguely. And that law remained in place until 2003, when we had Lawrence v. Texas and the Supreme Court overruled those laws.
On February 16th, 1978, Florida's Technical University, later named the University of Central Florida, formally recognized the Gay Student Association, the GSA, making GSA the first official LGBTQ+ organization in Central Florida. The organization underwent several name changes, first in 1994 to become UCF's Gay, Lesbian, and Bisexual Student Union, and again in 2009 to become Equal, reflecting students' desires for a more inclusive name. The organization's mission is to provide LGBTQ+ students with a safe space without fear of discrimination.
I think it's really important to recognize that the first group in Central Florida was our students. And I think that's real important to keep in mind. At this point, adults weren't doing much. Some of us were politically active, but there still wasn't this kind of very visual, we're going to get out there and be in your face kind of movement. The next slide, and I'm never sure which one of these to talk about first because they kind of go together. Unfortunately, Anita Bryant's anti-gay campaign won their battle using the trope of child molestation. On June 7th, 1977, Dade County, Florida, passed a referendum repealing the county's ordinance, which prohibited discrimination on the basis of sexual orientation. So they had an ordinance to protect people on the basis of sexual orientation. And because of Anita Bryant, they withdrew that. Okay, she and her husband, Bob Green, and their Save Our Children organization were very successful, unfortunately, using this sort of attack on the LGBT community, and it's been used many, many times. So then we had our wonderful law that if you were in a same-sex relationship, or if you were a single person who was gay, you could not adopt. And that's been around for about 30 years. It hung around before people started fighting back to change it.
So this is, I guess, a personal project of mine. I've been focusing on cross-dressers and female impersonators in Central Florida since the 1970s, and seeing the evolution of cross-dressing and how it played a role within the development of the LGBTQ community. So what we have here, we have Miss P and some other drag performers from back in the 70s. And even though they're all dressed up, back then it was considered a crime to be out in public wearing makeup or anything. There was a test where they would take a handkerchief to police officers and they would tell the person to wipe their face. If you were caught wearing makeup as a man, they would arrest you because you were falsely identifying yourself as someone else. So, but by 1984, cross-dressing, the cross-dressing ban was overruled. Circuit Judge Frank Kinney ruled that a defunct Orlando County ordinance prohibiting men from wearing women's clothing in public and vice versa violated constitutional rights. The Orlando City Council had already dropped the ban in 1982 during an overhaul of the city's code. The City Council had passed the ban on cross-dressing in 1948.
In 1989, a human rights ordinance was proposed in Orlando by Jim Ford, who is a member of the Coalition for Human Rights, and he was a local gay activist. Unfortunately, though, it never took off. It was not considered by the government in Orlando. And I don't want you to think that nothing else was going on in Orlando. During the 1980s, many support groups formed. The Center came into existence, Centaur, Hope and Help. We were really working hard to kind of come out and be part of the community and at the same time support ourselves.
In 1990, the Delta Youth Alliance became the first organized youth group in Central Florida to provide peer activities and social support to young LGBT plus persons. DYA was formed by Terry Disher and Jeff Horn and was the second youth group to emerge in the state of Florida. The Delta Youth Alliance has since evolved into the Gay and Lesbian Idea Exchange for Youth, and now into the Orlando Youth Alliance.
And I want you to keep in mind how brave this was. We had just gotten through Anita Bryant claiming that all gays were child molesters. And now you had people who were willing to create this group for minors. And I can imagine that at that time it was pretty scary. Jeff Horn died a few years ago. He was a friend of mine, but I only knew him when he was in the Orlando Gay Chorus. And it wasn't until I joined the museum board that I realized all the work he had done previous to that. So, okay, on March 7th, 1991, the Florida Department of Law Enforcement raided the Orlando office of TransAid and the home of its founder and director, Alfredo Martinez Garcia. AZT and other medications were seized. Alfredo was charged with dispensing morphine, codeine, and prescription strength Tylenol without a medical license to AIDS sufferers. Alfredo went to trial and was found innocent of all charges by the jury. I don't know if you've seen the movie Dallas Buyers Club, but that's a similar situation to here. And when you can't afford your drugs because they're so expensive and you don't have a government or a system that backs you up, these kinds of things came up all the time, and he was willing to get the drugs and then pass them out to people that needed them.
So during this time period, we're seeing a lot of protests happening as well, especially in, I believe there's a base, a military base. They were like protests.
Oh yeah, the military base.
And then,
It's long gone now.
Yeah. In 1992, The Lost Language of Cranes, a film dealing with a gay son coming out to his parents and his discovery that his father was also gay, was pulled from the broadcast schedule of local station WMFE, which was chaired by then Leon Hanley. In protest, a number of LGBTQ plus supporters spoke in favor of showing the film at the subsequent WMFE board meeting. Among these activists were radio personality Cleve Thomas, human rights activist Brian Arbogast, and the PFLAG, PFLAG member Chris Alexander.
Did you talk about the Center magazine? At the same time, Center Stage magazine refused to run an ad to advertise a gay chorus event because it had the word gay in it. And so we were dealing with a lot of censorship of that level. So you couldn't come out and be part of the community, even though you were, most of the time when the Orlando Chorus was putting on a show, they were raising money for different organizations in the community. So finally, what happened with that was we had two of our activists managed to get themselves on the WMFE board so that they were part of the group that was deciding what was going to be shown or not. And that was a huge thing.
It's not mentioned here, but during this time period too, there was a police officer that was fired for being gay. And it caused a tremendous uproar in Central Florida, to the point where even the KKK counter-protested and came. That was during the 90s, early 90s.
Okay. The first time a marriage license was denied to a gay couple was April 22nd, 1994. And that was Rocky Ward and Tony Childress went to try to get a marriage license. After that, I think it was probably every year after that until we were allowed to get married on Valentine's Day, couples, sometimes there'd be 30 of them, would go downtown to the courthouse and ask to get a marriage license and listen to the clerk say over and over again, no, I cannot give you a marriage license. But it was sort of like, it was such a wonderful protest because they weren't really doing anything terrible. And yet the strain it put on the court situation there was really great, I thought. So
in my research, it took a while for me to understand the significance of Disney within the LGBTQ community, especially here in Central Florida, especially a lot of the people that I've been conducting oral histories with. They've always mentioned Disney and they had like Disney stuff. And for me, it's just like, why there's such a connection with Disney? But then I came to realize with researching that Disney was one of the first companies that was really like out there, you know. So the Walt Disney Company began offering health coverage to the live-in partners of gay and lesbian employees on January 1st, 1996. The studio feared losing talented employees in the competitive entertainment industry, and analysts say.
And Disney also, from the time they opened, were welcoming people of different sexual orientations because they just wanted creative people. There was not a sense of, oh, we don't want this person working here. And so in many ways, Disney has really been there with us since Disney World was opened. Okay, and then the Southern Baptists also boycotted Disney and tried to get other people not to go there, not to buy their films, not to, you know, and it didn't do one bit of good. And they finally let that go. But that was in protest to Gay Days, which was never a Disney, you know, sanctified occasion. It was just people going together to the park, all wearing red shirts to be visible. And so because that was going on, the Southern Baptist Convention decided to boycott Disney. We had another instance in 1998 where we had purchased flags to go up on all the light poles downtown for our Pride Parade. And because of that, Pat Robinson claimed that Orlando was going to be subject to terrorist bombs, earthquakes, tornadoes, and maybe even a meteor. So gay people's flags, remember this, cause all kinds of natural disasters. Unfortunately, we were hoping that would happen every year, that they would put the flags up. But unfortunately, after that, they passed an ordinance in Orlando that said that unless it was a city supported organization, we couldn't put the flags up. So these were considered personal, not an organization.
Okay. Yes, okay. So the Orlando City Council passes gay rights measure on December 2nd, 2003. And a decision residents said will turn Orlando into a city of either tolerance or moral decay. A divided city council voted for chapter 57 to protect gays from discrimination in the private sector. The battle for chapter 57 was led by Michael Slaymaker.
And then Orange County followed in 2011. For some reason, that ended up being a much, much harder fight than the city. The city was like, at that point, more than willing to change, but the county was a little bit harder. Okay, yep, and now, then we have we had huge celebrations when DOMA and Proposition 8 were overturned by the Supreme Court. And then we have gay marriage.
On June 27th, Central Florida celebrated two major LGBT-related decisions. The first decision overturned the Nation's Defense of Marriage Act, which had marriage as being heterosexual, which had denied federal marriage benefits to homosexual couples, and which had allowed states to refuse to recognize same-sex marriages performed under the laws of other states. And the second ruling lets stand a lower court's decision on California's Proposition 8, thus again allowing gay marriages in California. Approximately 5,000 people attended the rally held at the Lake Eola band show in Orlando.
If you think about it, you know, if you're straight and you get married in one state, it's recognized all over the country. And in fact, it's probably recognized all over the world that you are a married couple. Patty and I got married in New York. And the reason we got married in Florida was we decided that if we had to, we would get married in every state once the states started changing. Because again, you know, rights get taken away as well as being given. And so at the time, but then I decided it was getting too expensive and it was way too much traveling. So, okay. And then gay marriage came through in Florida on my birthday, by the way. That's what was so cool about it. January 6th, remember that? And then it was legalized in Florida. Okay.
If you want to know more about the local LGBTQ plus history, check out our website and virtual museum at floridalgbtqmuseum.org.
Yeah, we have so much stuff to look at, many photographs. And now the major part of our archives, the part that really needed to be protected because things would mold and rip and crumble, is at UCF. And we're working on the MOU so that we will have this sort of joint custody of all our archival material. And it's really exciting. I think there's supposed to be a news article about it at some point soon. So thank you.
Thank you, Martha and Alexis, for that important overview of what's happening locally and here, even at UCF. Some people say that all politics is local. And certainly when you want to make a difference in our communities and our lives, on our campus, being active and engaged is very important, as Martha and Alexis have pointed out. Our next speaker is Dr. Matt Rickey. Matt serves as the Assistant Director and Title IX Coordinator in the Office of Institutional Equity here at UCF. In this capacity, Matt supports UCF's civil rights compliance portfolio, with particular focus on gender discrimination, sexual harassment, and related interpersonal violence. Matt's 18 years as a higher educational professional have included work in residence life, student life, care and case management, threat assessment, and civil rights compliance. Matt's passion for this work led him to earn a PhD in higher education and student affairs leadership from the University of Northern Colorado. Matt presents nationally on LGBTQ+ equity, Title IX, and VAWA compliance, well-being, and crisis leadership. Please welcome Dr. Ricky.
Okay, is this still on? Awesome. I don't have a PowerPoint. I decided to kind of boycott PowerPoints post-pandemic, so we're gonna try this without the benefit of visual aids. I don't know why. I just kind of got over them during the Zoom era. So my focus today is really going to be on two pieces of civil rights law that impact and influence our lives and work here at the University of Central Florida, and some things that have been happening on the kind of national level that have changed that over the course of the last few years. So many of you are probably aware of the two laws I'm going to speak about. The first is Title VII of the Civil Rights Act of 1964. Title VII was part of a group of legislation that went through as the Civil Rights Act that specifically prohibited discrimination on the basis of sex, among other categories, in employment. And so most employers in the United States, public or private, are accountable to Title VII. So they can't discriminate in employment on the basis of sex. That's the law as it was written in 1964. The Civil Rights Act also included a title preventing discrimination in education and discrimination in public accommodation, but both of those excluded the category of sex. So one could still be discriminated against in their attainment of education on the basis of sex, though not in their employment, theoretically. And I say theoretically because, as we all well know, civil rights laws do not change the social conditions immediately, right? They're an immediate remedy to a systemic and long-term problem that is going to take a long time to fully reconcile. So the Civil Rights Act didn't change sex discrimination in employment, it merely prohibited it moving forward, right? So that happened in 1964. And is going to be critical to some of the more recent activity around sexual orientation and gender identity non-discrimination under various civil rights laws. About 8 years later in 1972, Title IX of the Education Amendments went into effect. And it was actually signed into law by President Nixon. Most people kind of like twitch a little bit when I say that, but Title IX prohibited discrimination on the basis of sex in any educational institution receiving federal financial assistance. That included your K-12 institutions, your post-secondary institutions, as well as thousands of museums, libraries, medical education centers, and pretty much anything that had an educational scope or mission if they received any federal aid. So Title IX goes into effect. It prohibits sex discrimination. There's a lot of hubbub immediately after. Most people still today hear Title IX and they think one of two things. This is an athletics issue, right? Because most of the early days of Title IX involved the NCAA suing the US Department of Education to carve out athletics from Title IX compliance, because they thought, and this is a paraphrase, but it might as well be a direct quote, that somehow Title IX would cause the death of the institution of American football. Put a pin in that for a minute, because that's going to come back to haunt us again this past legislative session in Florida, that same kind of mentality and ideology. So early days, we really hear about athletics, so everybody thinks athletics. Of course, Title IX has also had a lot of recent attention since 2011, when the Obama administration released what they call a Dear Colleague letter, which is a significant guidance document saying, once and for all, that sexual assault is a form of sex discrimination prohibited under Title IX, and that institutions, K-12 and post-secondary, needed to take notice. because we're coming after you if you're out of compliance, if you're mismanaging these types of cases. By the way, Title IX does not just apply to students. It applies to everyone. No person in the United States shall be discriminated against on the basis of sex in an educational program. So it includes employees as well. So there's an overlap in an institution like UCF between Title VII's non-discrimination on the basis of sex for employees and Title IX's non-discrimination on the basis of sex within the institution altogether. So for those of us who are employees, we reap the benefit of dual protection under Title VII and Title IX, right? So it's not just about students. The reason that those are both very important for today's conversation is because we do not, to this day, have any state or federal civil rights laws that explicitly protect, codify sexual orientation and gender identity as protected categories in any setting: education, employment, public accommodation, healthcare, etc. We lack the basic civil rights that are afforded to other protected categories under Title VII, under Title VI of the Civil Rights Act, and other related state and federal statutes. The Florida Civil Rights Act and the Florida Educational Equity Act are also silent on this issue. Both of those state civil rights laws do prohibit discrimination on the basis of sex, but stop there, right? Among the other protected categories, we're often hearing about race, religion, national origin, disability, etc. So when the Obama administration ran the US Department of Education, the 2011 Dear Colleague letter, which talked about sexual assault, kickstarted a flurry of Dear Colleague letters about Title IX and its application within a setting like UCF, trying to get institutions to really wake up to the fact that, again, sexual assault is an egregious form of sexual harassment and thus prohibited under Title IX, that relationship violence and stalking are similarly situated behaviors and need to be addressed. In 2016, toward the tail end of the Obama administration, they released one last Dear Colleague letter. This was called the Dear Colleague letter on the status of transgender students. That Dear Colleague letter specifically stated that for the purposes of federal enforcement of Title IX, the protected category of sex was intended to include gender identity and gender expression. And so the US Department of Education and their enforcement arm, the Office of Civil Rights, would enforce Title IX compliance on institutions that discriminated against transgender students. That was pretty earth-shattering at the time, right? And remember, again, we have nothing at the state level or federal level that actually says that. And so there were two mechanisms that the federal government could employ to kind of assert that meaning and interpretation of Title IX. They could create an executive order or Dear Colleague letter, which is what they did with the Dear Colleague letter, or there could be a court battle settling the issue federally around Title IX. Around the same time in 2016, there was a case percolating that was going to go to the Supreme Court for review. That was Gavin Grimm v. Gloucester County. In that case, it was a K-12 Title IX case. Gavin was suing his school district for failing to provide him access to restroom and locker room facilities that matched his gender identity. And so that's a straight up discrimination claim, right? I'm not being afforded equal access. It got refereed up to the Supreme Court eventually. And then in 2017, the US Department of Education issued a rescinding document that said, basically all of the Obama era Title IX guidance is gone. Your 2011 Dear Colleague letter about sexual assault is no longer in force. Your transgender rights letter no longer in force. A lot of people were really shook by this 2017 Dear Colleague letter. This is a very short one that just said, we're rescinding all of these things. You have to remember, though, Dear Colleague letters are guidance documents. They don't carry the weight of law or statute. And so they're extremely, extremely fickle from a legal perspective. And so it went away just as easily as it came into existence with a change of administration. So when that happened, the Supreme Court picked up the Gavin Grimm case, but then they're like, well, you know what? The US Department of Education hasn't quite decided yet if this is a real thing or not, this transgender discrimination under Title IX issue. And so we are remanding the case back to the Fourth Circuit without opining. And so we had this opportunity potentially in 2016-17 to settle the issue of gender identity discrimination under Title IX, and then it fell flat. Now, the Fourth Circuit said, you know what, we're reviewing this and we do think that this violates Title IX, and they ruled in favor eventually of Gavin Grimm, well after Gavin Grimm was no longer subject to the predatory behavior of his district. And so that was great, and right, like many court victories, it came too late for the individual parties to the case, right? So still nothing on the federal level. The Supreme Court, even to this day, has not heard a Title IX case related to gender identity or sexual orientation. Over on the Title VII side, though, we did see some recent activity around that. We had in summer 2020, we finally received the decision in Bostock v. Clayton County, Georgia. So I'm going to refer to my notes real quick because there's a lot here to unpack. So Bostock v. Clayton County was 3 separate cases that had all been enjoined in the 2019 Supreme Court session because they all touched on similar questions. And so they decided that they were just gonna put them all together. The salient question in Bostock v. Clayton County was, is sexual orientation discrimination and is gender identity discrimination a form of sex discrimination that is prohibited under Title VII of the Civil Rights Act of 1964? It's a really good question. Interestingly, multiple circuits had decided that, yeah, it probably was. And other circuits had decided that they weren't sure or that it wasn't. And so there was this circuit split, as often happens around these issues. The 11th Circuit, where we are situated, heard the original Bostock v. Clayton County case because it was in Georgia. And in 2011, in another case, the 11th Circuit had already ruled that discriminating against somebody based on sex stereotyping, the idea that they should conform to the sex assigned at birth, was a violation of Title VII for the purpose of employment discrimination. And so in our circuit, since 2011, the holding has been anti-transgender discrimination is a form of sex discrimination prohibited under Title VII. Little did we know. Some of us did. But that had been here for 10 years almost at that point. So once that case went to court, it really opened up the opportunity to finally figure this out for Title VII purposes. As you're probably aware, the case took a very long time to review. I think they heard the case originally in, I want to say, October of 2019. And as these things tend to go, is a very, very short hearing, right? About 30 minutes back and forth for each of the sides, and then we move forward with the decision-making process, which takes a number of months thereafter. So toward the end of session in June of 2020, they handed down a 6-3 decision that, yes, Title VII's prohibition of sex discrimination does include gender identity and sexual orientation discrimination. Because, and the logic used prior case precedent, this failure to conform to sex stereotypes was a form of prohibited harassment and discrimination under Title VII for decades prior. In a number of different cases I'm not going to go into, most notably Price Waterhouse. And so that set the tone for this decision. Here's the interesting thing about the decision. It ties a little bit into Patty's history that she shared. This question about what's next for us with LGBTQ plus civil rights through the lens of this newly formed Supreme Court. Well, the Supreme Court was almost fully in its present iteration at the time that they decided on Bostock v. Clayton County. And so it was a 6-3 majority. Neil Gorsuch wrote the opinion, the majority opinion in that case, which surprised a lot of people. And then there were a couple of my colleagues who were like, no, that makes perfect sense because he's a strict constitutionalist who better to write the opinion. And he was careful in the majority opinion to say, don't overread this decision. It only applies to Title VII. It doesn't apply to all these other things. And it only applies to narrowly to gender identity and sexual orientation, so try not to make too much out of this. Well, it was huge nonetheless, because finally we had some judicial review that said this is prohibited discrimination, right? In employment only. Very quickly, in the change of administration then, federal administration, when Biden took office in January, he wrote a bunch of executive orders. And one of those executive orders said, based upon the Bostock v. Clayton County interpretation of the protected category of sex under Title VII, we're extending the same understanding of the definition of sex to all other federal civil rights laws, including Title IX. And so now, again, we've seen the pendulum shift back to anti-discrimination covers transgender identity, gender identity expression broadly, and sexual orientation as well for Title IX purposes. So because this was a 6-3 decision, there is some hope for the future. Now, one of those positions has shifted, right? So Ruth Bader Ginsburg was one of the 6. And so now we could anticipate if the same court was hearing the case today, it would probably be a 5-4, which is much obviously more narrow victory. But I still think there's some hope for the future because of that 5-4 split. So I'm thinking that if Title IX were similarly to go for judicial review before the Supreme Court in the current version, we would probably see a favorable outcome. That sexual orientation and gender identity discrimination under Title IX would also be problematic. So here's hoping, right? Minimally that would be a thing. There's still no federal civil rights law that specifically articulates sexual orientation and gender identity expression. I think this is where Patty may have been going toward the end of her talk with a piece of it. Because there is no law of the land, there is only a judicial review, a future court could overturn marriage equality, could overturn the Bostock v. Clayton County decision, could overturn a lot of civil rights judicial reviews that we think of as permanent somehow, right? But they're not permanent. Bostock v. Clayton County is a right now decision. We can't guarantee that it'll be there in the future. So it's very critical to take a look at the existing body of civil rights laws and push for broader language. The Equality Act at the federal level, something similar at the state level, where you're specifically writing in sexual orientation as a protected category, gender identity and expression as a protected category. Because those, once a law is enacted, can stand up a little bit more to the test of time than can even a Supreme Court decision. The executive order that extended that definition to Title VII, the Bostock definition to Title IX, doesn't stand the test of time. A new federal administration could come in and undo that executive order as easily as Biden undid a number of executive orders from the prior administration. And so it's really critical that we look at civil rights, not from the lens of can we win this Supreme Court case, but from a multifaceted, multi-front lens of we need local, state, and federal judicial review, legislation, and policy coalition making. So we have at UCF, for instance, despite the lack of state and federal protections explicitly written into law, had sexual orientation in our non-discrimination policy starting in 2007. Paralleling some of the cases that you mentioned, right? And it made sense, right? You can't really have a city ordinance and also not extend the same thing to UCF, who's a City of Orlando employer. And then in 2011, we finally got around to adding gender identity and expression to our non-discrimination policies. Despite the back and forth of what was happening at the federal level with respect to gender identity and sexual orientation non-discrimination, UCF has held fast in our commitment to ensuring non-discrimination through our programs, activities, services, education, et cetera, over the course of the last 15 years, because we recognize how important it is to make sure that our community is safe and inclusive for everyone, regardless of sexual orientation and regardless of gender identity. So my office, the Office of Institutional Equity, is the Civil Rights Office for the University of Central Florida. We can and do receive concerns regarding gender identity and sexual orientation discrimination, discriminatory harassment, and discrimination on a number of other protected class bases. We've got some handouts in the back that talk a little bit about what our office does and how to get hold of us should you ever have an issue. But know that we are here for you, for all of our community members, and will continue to be no matter what happens at the state or federal level. That said, I'm going to end on a slightly gloom note. The state of Florida has launched a fairly concerted attack on the rights of trans and queer folks here in the state. In 2020, we saw the passage of the so-called Fairness in Women's Sports Act as a rider to the Charter Schools Reauthorization Bill, which basically said in K-12 and post-secondary education, trans women, exclusively trans women, can't participate in women's athletic offerings at the competitive, club, or co-recreational levels, which is absurd. I wrote a pretty, I thought it was forceful letter to the state of Florida and to our own administration here at UCF to try to compel them to action as the bill was still percolating through Congress, and that did not go anywhere. Anyway, so that passed and that was implemented in June. In response, we had to figure out what this means because we've got now a competing priority between Title IX and state statute. And so we made it so that all of our co-rec or our rec sports offerings here at the university are all degendered now. There's no gender, there's no men's rec sports and women's rec sports. They're all just rec sports. We're still working on trying to figure out how to address that at higher levels. Intercollegiate athletics, that hasn't come up yet. I have a feeling it will. We also are forecasting to the 22 legislative session. We have 2 pieces of legislation that were posted for review that codify a Trump era executive order into legislation. So there was an executive order under the Trump administration. I want to say it was in 2018 or 19. I'm losing time because of the pandemic. That was basically it was called an executive order on race and sex stereotyping. It's the executive order that would have made federal contractors like UCF unable to teach critical race theory and other what they called contentious topics or divisive concepts, I think was the phrasing that they used. That has verbatim been copied and pasted into pending legislation for the 2022 legislative session. So I would encourage you to go out there and look at that. We already have had issues in the state of Florida because we do have a K-12 ban on the use of critical race theory that interprets that ban to also include pro-LGBTQ plus content. So if we want to, again, think local, act global, think global, act local, do all the things on all the levels, consider ways in which we have to focus on local and state level political issues. We can't just rely on Supreme Court decisions to settle the issue of civil rights for us. We have to take matters into our own hands. Thank you.
Thank you again, Matt, for those insights on Title IX and Title VII at the federal, state, and university level. Also, thank you, Matt, for your advocacy and leadership in addressing these issues on campus. It's important to have an environment where all people on campus and across the state, across the country, feel comfortable and are welcome to work to the best of their abilities. Our final speaker today is Angela Warnsice. Angela is the UCF Pride Faculty and Staff Association president, and also works as the administrative coordinator in the School of Politics, Security, and International Affairs. Please welcome Angela.
Hello, everyone. I will be very brief because I am not a subject matter expert in this area, but I did want to give a little bit of history of PFSA and a little bit of, what we do since we are, one of the hosts of this event. I've worked at UCF for about 16 years, and, as the current president, of course, it behooved me to learn, how did this come about? So PFSA informally started back in 2011 and then formally incorporated in 2012. Our membership is limited to faculty and staff, but we serve faculty, staff, and students. We do a lot of things such as holding inclusive events to help educate the public. We create safe and brave spaces for our faculty to gather for networking and fellowship, because there are some issues that, we need to have a space that we can come together and talk about those and be better employees by, banding together for our common issues. We work closely with a lot of other organizations, both within and without UCF. We recently had a team that participated in the 4th annual drag race, and they raised over $900 for the Zebra Coalition to help them provide services to LGBTQ plus youth. We are also partnering with the One Pulse Foundation to create opportunities for faculty, staff, and students to work with the foundation in a variety of methods, such as educational outreach and internships. One of our biggest collaborators is, of course, within the UCF community, and that is with LGBTQ plus services, who are part of the Social Justice and Advocacy Department. A lot of our members work with the Alliance Mentoring Program, or AMP, which is an excellent program. If you have never participated, please do. I know I've been personally very enriched working with my mentees. They have taught me a lot about myself, about their life experiences that, because there's certain things you can't learn, without experiencing them. And so the closest you can get is sharing somebody else's experience. And so it's just been really valuable. So please do become a mentor or a mentee if you're a student. Another thing that they do that I absolutely love and that we partner with is they host the Lavender Celebration for graduating queer students. And PFSA comes and we hand out the lavender stoles, and most of the time the speakers are members of PFSA. And, that's just like another really wonderful opportunity to celebrate the youth as they are leaving us. Unfortunately, it's so sad to see them leave, but, it's a great celebration of all the hard work that they did here and all the changes. And so I'm just really proud and excited that I have gotten to participate in that event. And then I also wanted to give a little plug. We do have an event coming up next Thursday, which will be from 11 to 1. It is a pumpkin painting and picnic event, and it will be over by the Arboretum. If you have any questions, concerns, please feel free to reach out to me at pfsa@ucf.edu. I do have some cards in the back that have our email address and Facebook page on there, as well as our website. So you can get further information, see past newsletters, and find other ways to connect with PFSA. And I also want to take this moment real quick to thank all our speakers and our moderator. I really, really appreciate all the hard work that you guys did. It's a little unfortunate that we didn't have a better turnout for this event, but that does not negate the quality of work that you guys did and how much, how thankful I am for the time and effort that you put into it. So thank you. And I guess, can we all gather up front and we'll give opportunity for Q&A. And if there's no questions, then I definitely want pictures with our lovely new tablecloth that we're finally getting to use for the first time. Speakers.
I actually have a question too. So the distinction between Title 7 and Title 9. I mean, as a technical member administrator, that also sometimes confuses me, to be honest. And also when you talk about this contestation about the conceptualization of sex, gender identity and expression, do you want to elaborate more about this issue, because they're actually very interested, just from a political view, and I would appreciate maybe it's just you give just more context for people like you who are, maybe I can say like semi-ignorant.
Sure. Is this on?
Oh, if not, it might have gone.
There we go. Okay. No, those are great questions. Thank you. So the Title 7, Title 9 differences. There are different laws that went into effect at different times, which created non-discrimination statutes for different kind of categories and classifications. So the Civil Rights Act of 1964 was actually written to solidify precedent court decisions about desegregating schools and public accommodation spaces, things like that. So there's multiple titles or sections under the Civil Rights Act that impact different areas in terms of non-discrimination. So Title 6, which I mentioned, is non-discrimination and public accommodation. The reason that that title was part of the Civil Rights Act was specifically, for lack of a better historical reference point, the desegregation of water fountains and restrooms. So Title 6 says there won't be any discrimination in public accommodations on the basis of race, color, ethnicity, national origin, or religion. Title 7, which was another subsection of that same law, was specifically talking about non-discrimination in employment. So as an employee, I have the right to not be discriminated against on the basis of my race, ethnicity, national origin, religion, or sex. And so it was, I believe, the only title in the Civil Rights Act that actually specifically said sex. In 1964, when that law went into effect, and in 1972, when Title IX covered education's non-discrimination on the basis of sex, that time frame held under the law that sex was about whether somebody was biologically male or female, right? Because that was the social, political, and biological understanding of sex, and the legal one. Over the course of time, both Title VII's definition of sex discrimination and Title IX's definition of sex discrimination have been contested through the courts to expand in the 80s and early 90s to include sexual harassment as a form of sex-based discrimination, regardless of the genders of the individuals engaging in that conduct. So unwelcome sexual conduct in the workplace, unwelcome sexual conduct in the education sphere were both determined by courts to be a natural extension of sex discrimination under those statutes. And then we started seeing that expand in the late 2000s, well, it would have been 2016 to present, to include sexual assault, for instance. Sexual assault is an egregious form of sexual harassment, which is problematic on both a Title VII in the employment space, right? It's a civil rights issue, not just a criminal issue, as well as in education under Title IX. But because Title IX's coverage includes anyone within the university or K-12 environment, students, faculty, staff, visitors, guests, et cetera, there's a little bit of an overlap between Title IX's protection and Title VII's protection for those of us who are employees. Regardless, the institutions, the employers that are covered under those federal civil rights laws have to adopt their own non-discrimination policies, how we operationalize that on the ground. And so we have our non-discrimination regulation, we have our non-discrimination policy, and we have our Title IX grievance policy, which cover all of those pieces. So in recent court cases, so in Price Waterhouse, which I think was in 1992, I might be wrong about that year, that was a Supreme Court case where the court decided that sex stereotyping was a form of sex discrimination prohibited under Title VII. So if I perceive you, employee, as a woman, I have a specific expectation of what that means for workplace. You have to have long hair, you have to wear an ankle-length dress, you have to conform to my stereotypical notions of what it means to be a woman. And if I treat you differently because you don't conform to those stereotypes, that's a form of sex discrimination. So by natural extension, a trans person who fails to conform to my notion of what you should look like based on your biological sex assigned at birth is a form of sex discrimination. And that's what they found in Bostock v. Clayton County, because one of the petitioners was a trans woman, and their employer refused to acknowledge their transition to being a woman and continued to refer to them as a man and treated them hostilely during their transition. The Supreme Court decided that was a form of sex discrimination that was unlawful under Title VII. And so the legal understanding of what does sex mean as a category of the human experience has shifted and evolved over time to lead us to the place we are now. The difficulty is that that case only settled the issue for Title VII's purposes. There's non-discrimination laws that include sex as a category in education, Title IX, in housing. You can't discriminate against somebody in housing on the basis of sex, and a number of other, healthcare, those types of things. So all of those other laws that say you can't discriminate against somebody in this sphere on the basis of sex never changed. And still haven't. And that's where the legal contestation is right now between Title VII and Title IX. Did that help a little bit? Awesome.
Questions or comments? Comments from the panel on anything or other issues? As I mentioned at the beginning, we can only scratch the surface on some of the issues around LGBTQ plus law and politics. So if anybody has any questions or comments or wants to raise a topic for discussion, please feel free. Michael.
I would love to hear how you all, I work with students a lot, and I think these are all very important conversations to have with students. How do we provide this type of information? I love this. I love DCF history. I'm also going to DCF a lot. So I'm more invested in learning about DCF. Like, how do we break down laws, rules, like the history of all of this?
At least from the law perspective, Title IX, Title VII, all the laws, it doesn't actually matter. What matters for you at your experience here at UCF is we have policies in place that say you can't be discriminated against on the basis of who you are, on your sexual orientation, on your gender identity, your race, your ethnicity, etc. That's part of policy. That's in university policy. It doesn't matter what's happening on the federal level. It doesn't actually matter what's happening on the state level for that purpose. Here at UCF, you belong, right? And that policy says so. That policy also creates a mechanism where if you are discriminated against, you can do something about it, right? And again, regardless of what's happening up here, out here, here at UCF, that is true. It's also true, it happens to be true also in Orange County and in the city of Orlando and some other places throughout the state. But for the purpose of you being a student here at UCF, you matter, you belong. Employees, you matter, you belong, and we have policies that say so.
Yeah, the other thing, if I could just weigh in real quick, I was able to get back out of my meeting and having to pop in. We know that there are limits to what the university can do under the control of the state legislature and also the governor. That we may have policies, we may have efforts that we want to see, in practice, but both the federal government through various means of control and the state through direct executive orders and legislative orders, laws, can in fact force that change of those policies. An example of that is we're not able to, require face masks. We're not able to ask about vaccination status. This has come from the executive orders of the governor. So as a state institution, we may have policies, but those policies can be tenuous at best. I agree the culture there is that, diversity, inclusion, but how long that lasts under some of the challenges that we have happening outside of the university, I'm not sure. And that would be the only thing I would just add to that.
In terms of history, I didn't know about like Orlando's LGBTQ history until my grad school, which is unfortunate because there's so much history here, I think one of the ways that we can kind of reach out is having a conversation with the students about, there are LGBTQ histories, Central Florida history, South Florida history, and they're all interconnected, right? So for example, like our museum, it's a volunteership. Everything, what we're doing right now is we're both volunteers. We have titles, but we're volunteers. And I think if the conversation could be stirred up with the community itself, with the younger generation, come participate in collecting oral histories or learn how to archive, whatever the case is, this can at least provide a foundation for them to understand our history and then push forward the narrative. But like I said, I learned about our history in grad school, which is unfortunate because there's so much history and I've been here all my life,
Oh, thank you. One of the reasons we do this is for the younger generation, because if it all gets lost, they're never going to hear about it. And they're certainly not going to learn it in school, and they're not going to learn it from their families, and they're just not going to learn it at all. And so we've done quite a few of these presentations together. We've done at the library. We gave a presentation at OYA Summit last year. We'll probably get asked to do it again this year. Believe it or not, the history is very popular, so among the students and stuff. But I mention things in class, but I don't teach history. I teach writing. And so it's not like I can just say, you're going to listen to all this. But when things come up, I answer questions. I have several believe it or not, trans students in my class this semester, and we often talk about what their rights are as compared to the other students. And how they feel here, if they feel safe. I mean, I think all of those things are real important, but I don't know how to do it really how we could do it within a class that already has, you know, a set curriculum. It would be hard. I mean, maybe in history, you could actually have a Florida history and have it be gay themed. I don't know. But I mean, I do teach queer theory, and that's one place where I can do it. But it's difficult, you know, and I don't always feel safe either. If you want to know the truth of the matter, I've had enough run-ins with people here in the past 23 years that it doesn't always feel safe for me. So I don't know, maybe not the answer you wanted, but it's the only one I have.
And I believe you also have. But I believe you still have pride chats, right? So maybe that might be one of the vessels that we could use to reach the students. And then we used to do the living library, you know, and I think maybe, you know, that would be another area where we could, you know, record some of these presentations and get them more widely distributed to the student population.
I also put a plug in for my home department. The School of Politics is offering an LGBTQ plus politics course in the spring semester. And there are a number of other courses. Dr. Shell teaches literature of AIDS. He was here a little bit ago. Barry Sandler teaches, I think, a film course on LGBTQ topics. Another idea I had too is maybe we need to meet the students where they're at. So at the library, there could be an exhibit on LGBTQ plus history in.
Actually, we can promise that
Yep.
we're moving the archives over. So
Right.
we will have exhibit space all the time.
So that's a great, yeah, it's a great way of, you know, educating, celebrating, and motivating, right? I think USCF has got a good history. I think Martha and I were founding members of PFSA way back when. I think, you know, the university has made a lot of progress. You know, it's notable that UCF allows for a student to choose his, her, their gender pronouns, the name of choice on web courses, and housing. So that, you know, there's a connection between sort of this history and where we've been and where we're going through politics, advocacy, leadership. So I think we should be celebrating and motivating our people in the community because we've accomplished a lot and there's a lot more good work to do.
Sorry, another thing, too. I've noticed with like my work doing the outreach, I connected with the community that I never knew about, right? So I think, especially for the younger generation at UCF, if they could at least figure out a way, either volunteering at the center, on Mills, or with the museum with us, or any other way to connect with the older generation, because that's the part of the history that you guys want to connect with, right? You want to preserve that history, but learn from them as well. And so with doing the outreach and everything else, it kind of like lit a fire under them. They were excited, they were motivated, even though they were part of the history, they wanted it to be preserved. So like now we're seeing like a massive influx of like people donating things to the archives, want to do oral histories, and we need help.
Yeah, definitely. And Alexis was an intern, and that's how I got to know him. And then he joined our board because he just found it so interesting. We've also had a few deaths in the community in the past few years, and there's that sense that, oh my God, everybody that knows things is going to be gone and we're not going to have it. Alexis has been collecting oral histories like crazy, and they're wonderful. We have a lot of those in our website as well. So we do need help. So, you know, if your student needs an internship, believe me, we could find something that would fit what they need to study without any problem.
Other questions, comments, observations?
I appreciate your the history that you shared today, because as someone who's not from Florida, I came to Florida 6 years ago, I guess now. So becoming more aware of what the path here is very helpful to me. I appreciate it. And, you know, it's so frustrating, I think, that we can't pass laws so that we have to rely on judicial reviews and how people believe things should be interpreted. And one of the things that I thought about is where are the safe spaces where people can gather to be able to talk about things and to be able to feel like they can ask the questions that they want to find out. I mean, you didn't find out till you were a graduate student. Was there a place that you could have gone before that where you felt like you could ask the questions you wanted to ask? And now that we've been kind of looking in Nicholson about creating a place where people feel safe and feel able to thrive in the environment that we create. And we've been doing some informal surveying, and we find some areas students don't feel comfortable, they don't feel safe, they don't feel comfortable. And other places they do. Certain faculty, they feel comfortable around other faculty, they don't. And so it seems like maybe being able to to continue to work together to find those safe spaces and then communicate those spaces to.
Well, we used to have things that we put stickers.
I have one on my door. I have one on my door.
Yeah, and that I thought was helpful. Of course, now they're not allowed in our building and in our offices, so.
I have it on portable thing that's not my desk.
Oh, I love it.
But anyway, I just wanted to. I can't say anything to you that other than to say that I appreciate and respect your goals and your aspirations.
Hello? Okay. My name is Eno Turner. My pronouns are he, him, and I work with LGBT services. I'm on the Lavender Council, and we have designated like 3 safe spaces, like specifically defined for people to feel safe and comfortable, like and not have to worry about like being harassed for their identity or expression. And these are the Social Justice and Advocacy Lounge in the Student Union, Pride Commons, which is across from 63 South, and the Multicultural Center, yeah, which is also the Student Union. And we're also working on bringing one to the Rosen College downtown. And I'm sure what Michael was hinting at, asking earlier, is if we could like do collaborations and sort of bring like your expertise in the legal field and history, like, and do something in those spaces, or maybe do a collaboration with our services to like just directly get to the students where they feel comfortable.
Is there a way, I'm down at UCF downtown.
Mm.
Campus, and maybe there's a way that we could be a place where we could designate area in. Also, I'd like to, we are in the process of creating equity advocates. So in each of our program areas to work with our culture. And I would like us to do something more direct, and that would be something that we could do, work together. And I will, I'll give you I've got a card with me so we could exchange email with me.
Yeah.
And then I can connect you conversation more, because I think the downtown campus is not a remote outpost. It is part of the campus and its students there as well. And so we need to, that having some space there that would be a designated safe space, I think would be great. I would like to support.
Cool. I will talk to the project leader on that.
I'm sorry that I was looking back there. I don't think we.
Oh, no, it's good. This is great, having this kind of collaboration. Any other final comments or thoughts?
Let's learn from our history.
Yeah. Thanks again to the School of Politics, Security, and International Affairs, and to the Pride Faculty and Staff Association for hosting and sponsoring this event. It was very worthwhile, and just even the collaboration, the insights, the discussion, the collaboration is very valuable, and we appreciate it very much. So thank you. Thanks to all.
And you could not use that during the meeting, but there are some professionals who can talk. Because it's all handled outside of the field, it's fine.
Right.